The legal situation of the shipwreck Nuestra Senora del Juncal, ownership and protection under international law. On 31 October 1631, the Spanish galleon Nuestra Senora del Juncal succumbed to a storm and sank near the coast of Campeche, or Mexico. From a legal perspective, Mexico and Spain retain a legal interest over the wreck as coastal state and flag state respectively. This article examines the legal situation of the wreck in the light of international law and bilateral instruments between Mexico and Spain. In the first section, this article examines the issue of the ownership by considering the Juncal as a Spanish state vassal vested with sovereign immunity. Yet, the article also argues that Spain transferred the ownership of the wreck to Mexico during the state succession of 1836. In the second section, the article examines the general obligation to protect and preserve the Juncal as underwater cultural heritage pursuant to the 2001 UNESCO Convention on the Protection of Underwater Cultural Heritage. This research argues that the general obligation requires from Spain and Mexico a duty to cooperate and due diligence obligation. On 31 October 1631, the Nuestra Senora del Juncal, or the Juncal, one of the flagships in escorting the New Spain fleet, sank during a storm near the coast of Campeche, Mexico. During the second half of the 20th century, expedition attempted to find the wreck, although without further information about its location. Archaeologists and historians have relied on Mexican, Spanish, and Cuban archives to study inter alia the nature and features of the ship, the cargo, the social context of the crew, the road, and the possible location of the wreck. From a legal perspective, Mexico and Spain have legal interests over the wreck as coastal state and flag state respectively. Both are parties to the United Nations Convention on the Law of the Sea, or UNCLOS, and the 2001 UNESCO Convention on the Protection of Underwater Cultural Heritage, which constitute the main legal framework to protect underwater cultural heritage. Furthermore, certain bilateral instruments are relevant to elucidate those legal interests, namely the 1836 Definitive Treaty of Peace and Friendship between Mexico and Spain, and the 2014 Memorandum of Understanding for Cooperation in the Identification, Management, Research, Protection, Conservation, and Preservation of Underwater Cultural Heritage. The available historical and archaeological information enables the legal analysis of at least two aspects of the wreck: the ownership and the right and obligation that Spain and Mexico have towards the protection of the wreck. The scholarship on the governance of underwater cultural heritage before and after the 2001 UNESCO Convention is vast. This article contributes by examining the particularities surrounding the ownership of the Juncal and the right and obligation of each state. Concerning ownership, this article examines the rule of state property as a first argument. It builds upon the rule of state succession to the argue that after the 1836 state succession between Spain and Mexico, the former could have renounced any right over the wreck. This argument seeks to foster an alternative to the argument of state property and immunity over warships and official vessels carrying cargo extracted from former colonies. Regarding the protection of the wreck, This article explores the obligation that Spain and Mexico should observe under international law to protect the wreck against natural deterioration and commercial exploitation. In this regard, the paper highlights the bilateral cooperation effort between Spain and Mexico toward the protection of underwater cultural heritage, which represent good practice. This article presents four main sections. First, it provides a contextual overview of the governance of underwater cultural heritage. Second, it presents an historical and geographical factual background of the Juncal. Third, the article examines the argument concerning ownership. Finally, this article elaborates on the obligation that Mexico and Spain should observe under the 2001 UNESCO Convention. Governance of underwater cultural heritage. Technological development opened a new chapter in ocean exploration, including access to shipwreck located on the deep seabed. In this context, maritime archaeology developed in the second half of the 20th century because of this. From the use of scuba diving to the more recent LiDAR scanners or remotely operated underwater vehicles or RUV, powered with artificial intelligence and other features. Unfortunately, as elsewhere, some government and research institutions may be unable to afford the newest technology, and they instead rely on private companies with the financial means and infrastructure to conduct underwater operations. Issues arise when these private companies launch expeditions with commercial purpose. An example is Thomas G. Thompson, who discovered the SS Central America in 1988 and obtained funding from investors to bring the valuable cargo to the surface. The outcome was the loss of important cultural objects. Another example is the British vessel Diana, who sank in 1817. In that case, Malaysia contracted a salvage company to search and locate the wreck, bring the cargo to the surface, restore it, and arrange for the auction of the item by the auction house Christie's. The salvage company recovered 24,000 pieces of Chinese porcelain, from which Malaysia reserved from sale some item, leaving the rest for the auction. As explained by Bass, treasure hunting doesn't equate to archaeology in societal value largely because salvage companies aim to achieve profit in order to repay the financial backers of their search and salvage operation. Even those inclined to conserve the non-sellable item from their side cannot wait for decades to repay sponsor. It is also necessary to shift the cultural conception from shipwreck as treasures to shipwreck as cultural heritage. From an archaeological perspective, shipwrecks are time capsules well preserved by the ocean, which provide vast information on the social, economic, political, or anthropological development of mankind in a determined period of time and region. In international law, the conception of this object developed to the point of considering them as cultural heritage and prohibiting their commercialization. A first stage of this development is the 1982 UNCLOS, which governed this object as archaeological object in two provisions. Article 149 fosters the protection of shipwreck for the benefit of mankind as a whole and to pay due regard to preferential right of state of historical or cultural origin. Article 303 follows the same pattern and enables coastal state to exercise jurisdiction to this and over the contiguous zone. It also recognizes the right of identifiable owners, the law of salvage, or other rules related to cultural exchange. Nonetheless, the Convention is silent on aspects such as the commercialization of shipwreck or the applicable regime to shipwreck found between the contiguous zone of a state and its exclusive economic zone. Thank you.